The choice of a lawyer is an important decision and should not be based solely upon advertisements.
Hi, I'm James Pavizian. I'm an attorney with Parmele Law Firm, and what I'd like to talk to you about today is effective testimony at administrative law judge hearings. One of the most common concerns I hear from clients is anxiety about how to testify or what if they say the wrong thing. My response to them is always very basic. I tell them, hey, as long as you're being honest with us, there's no right or wrong. But it is a little bit deeper than that, and I want to talk to you about what makes testimony at administrative law judge hearings effective and what's ineffective. The most important thing a client needs to understand is that when you're testifying to a judge, there's a specific language they're used to hearing. If you go into a hearing and you talk about your conditions, like I have degenerative disc disease or I have anxiety, the judge is not going to understand what problems you're actually trying to convey to them, because the administrative law judge is trained to evaluate symptoms and limitations. So let's define some of these terms before we move on. A medical condition is, for lack of a better way of saying it, a diagnosis. So degenerative disc disease, anxiety, depression, ovarian cancer, breast cancer, these are all medical conditions. It is very uncommon in Social Security hearings that judges or Social Security disagrees with what condition you're dealing with. So oftentimes they're going to agree you have the problem you say you have. Second is symptoms. What is a symptom? So if degenerative disc disease is a medical condition, then pain is a symptom of that condition. So the symptom is what you feel because of the medical diagnosis. And then limitation is a thing you cannot or can do because of the medical condition and symptoms you experience. So going back to our example of degenerative disc disease is a medical condition, pain is a symptom, and not being able to lift more than 10 pounds is a limitation. When the judge is listening to your testimony, what they're really focused on hearing from you about are your symptoms, so pain, and the limitations, not being able to lift more than 10 pounds. Now again, this is a very basic formulation, but it holds true to any medical condition you're dealing with. The number one mistake I hear at hearings is people focus so much on the medical condition, they lose sight of the symptoms and the limitations. So why is this important? It's important because when a judge is listening to you, they are trained to formulate what's called a residual functional capacity. For lack of a better way of saying this, they're trying to figure out what you can and can't do in a workplace. So when they're listening to you, they're thinking about, well, how much can this person lift? How long can they stand? How far can they walk? Can they sit an hour before they have to move around or lie down? How long can they focus and concentrate on even the most basic tasks? Are they able to work in the heat or in the cold? Can they climb a ladder or rope? Are they able to kneel? Again, these seem very basic to you, but at the end of the day, this is how the judge decides whether you're disabled. So we at Parmele Law Firm and your attorneys, we're going to ask you questions about the things you can and cannot do. It may seem funny to you when we're asking you if you can do the dishes or who does the laundry. We're not asking because we don't know. You've answered these questions multiple times on different forms you've already completed. But at the hearing, we're asking these questions so the judge can conceptualize and see through your acts what limitations you have. Sometimes we'll just be blunt about it. We will ask you, hey, how much can you lift or how long can you stand? Again, it seems basic, but we're asking these questions because the judge is going to decide those very same questions. And so if you don't say these things to them out loud, they're not going to be able to figure out what it is you're actually communicating. The other thing you need to understand when you're testifying is that the judge is listening to what you have to say and comparing it to what they already know about you in your file. As we've said in our other videos, including a prep video that you may have seen already, the judge's responsibility is to review all your medical records before the hearing and come and listen to you talk about your limitations. So a lot of times these judges already know a lot about you. So when you're testifying, it's very important that you do not over-exaggerate or under-exaggerate your symptoms. You do not have to prove that you need to be in a wheelchair 24/7 or that you should be in hospice care to get disability. A lot of times, all you have to prove is that you have the limitations that you genuinely deal with. So it's just important for you to be honest, open, and answer any question you have without being evasive. If you have any questions about what you're asked to respond to, just ask. You don't have to feel discouraged if you don't understand what the judge or the attorney is asking you. Please let them know that you don't understand the question, and they'll rephrase it in a way that makes sense to you. At the same time, if you didn't hear the question, please don't answer it. Don't try to make up the question that you thought was being asked. Just ask for the judge or the attorney to repeat it, so then you can answer the question that was asked. Finally, if you just don't know, and honestly this is the hardest thing most of our clients deal with, is if they don't know the answer, just say, I don't know, I don't remember. I promise you, no one's going to get mad at you. The judges do not get upset with you if you cannot recall or you don't know the answer to a question being asked. Remember, this is your opportunity to tell the judge everything you know about your limitations. So if you don't know something, just admit it. The attorney and the judge will move on to the next question. At the end of the day, you will have a time to talk to your attorney before the hearing to go over some of these questions. There may be some very specific questions in your case related to the facts, such as where you may have worked at a certain place, or what you did at that job, or maybe something very specific about something a doctor told you in the records. These are things your attorneys will prepare you for. But big picture, the most important thing you can do is be honest. Be honest about your symptoms, be honest about your limitations, focus on the things you cannot do rather than the things you wish you could do, and let us know, and your attorneys know, if you don't know something, don't understand it, or just need it clarified. Thank you.